I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. Aaron Judge of the New York Yankees and the Major League Baseball Players Association went to bat before the Trademark Trial and Appeals Board over trademarks related to Aaron Judge. That's what we'll be discussing on this installment of the briefing by the IP Law Blog. Welcome to the briefing. Today we have some interesting news coming out of the sports world. Aaron Judge, the New York Yankees captain, has successfully blocked a Long Island man's attempt to secure trademark rights on judicially themed slogans, "All Rise" and "Here Comes the Judge" for apparel. The Trademark Trial and Appeal Board issued a 61-page precedential opinion stating that Judge and the Major League Baseball Players Association had priority of use over Michael P. Chesina's use of "All Rise," "Here Comes the Judge," and a logo design with an image of the scales of justice superimposed on a baseball field, all three of which were intended to be used in connection with certain articles of clothing.
According to the TTAB, Judge and the Major League Baseball Players Association presented evidence of third-party licenses that paid royalties to use words and designs referring to Judge, often including judicial terminology, on apparel since 2016. Chesina did not use the marks until he filed the application in July and October 2017, which worked against him.
That's right. The Chesina argued that Judge and the MLBPA's prior use of "All Rise" and "Here Comes the Judge" did not function as source indicating trademarks and were only meant to engender acknowledgement of, enthusiasm, and overall support for Judge. In other words, he argued that the use was ornamental. But the TTAB stated that the consuming public recognizes the subject slogans and symbols carrying judicial connotations as pointing to only one baseball player on one major league team.
Chesina claimed that he was not a baseball fan and had no knowledge of Judge until some point in 2017. He said that his creation of the marks in question between 2012 and 2015 stemmed from his interest in developing a new sports product.
Still, Judge and the MLBPA argued that Chesina adopted his marks in bad faith. The TTAB noted in its opinion that Chesina's timing and choice of marks and colors are indeed eyebrow-raising, and his protestations of good faith strain credulity.
The TTAB also stated that it was the perception of the relevant public, i.e. baseball fans, rather than the party's intent that determined whether a designation functioned as a trademark.
Overall, the TTAB deemed the evidence sufficient to negate Chesina's protestations of good faith, and Judge and the MLBPA were able to successfully block his attempt to secure trademark rights on the slogans. What do you think, Scott? Is this the right outcome?
Well, Josh, it sounds like Judge and the MLBPA were able to establish that the use of the trademarks on apparel were basically an indicator of secondary source. I assume that the third-party licenses that they submitted as evidence and probably other evidence showed the use of the mark on goods or in connection with services other than those listed in the application, other than apparel. And if you are able to show use of these particular trademarks on goods or on services other than the good that is claimed to be merely ornamental, that's how you establish secondary source of the mark. That's an indicator of secondary source. So, although I haven't read this case and I haven't looked at the evidence that was submitted by Judge and the MLBPA, I'm going to assume that the TTAB, given the length of the opinion, did sufficient analysis and got to the right decision.
I think that's right, Scott. And just to give a brief overview of what the TTAB looked at in reaching this conclusion, essentially it looked at the license agreements and said, look, they've been licensing these goods to third parties. They looked at a declaration from his agent, Paige Odell, which also supported that. And then the TTAB also looked to the fact that Judicial phrases and symbols signify, Mr. Judge, to the relevant consuming public, and that's the sports fans and baseball fans in particular. And interestingly, the TTAB wrote that Mr. Judge is the only baseball player with a judicial sounding name in Major League Baseball, and so they found that this was, to the consuming public, an indicator of source. And so I would say this is the right conclusion.
Yeah, it's an interesting case, and I think maybe we'll have to take a look at this and see what this case might do for other celebrity brands and other celebrities who feature their brands on goods and services, including merchandise, and how other celebrities should follow this precedential decision as a playbook for establishing solid trademark rights in their branding.
I agree, Scott. We'll have to take a look at that.
Yeah. Thanks, Josh, for sharing this. As always, another very interesting edition of the briefing.
Thanks, Scott.
Well, that wraps it up for this installment of the briefing by the IP Law Blog. We hope you enjoyed this episode. Please remember to subscribe to our podcast and to our YouTube channel. We have over 100 other episodes for you to listen to or watch. And if you're interested in more content like this, well, please visit us at the iplawblog.com.